Okay, so on this webinar today, we are going to be talking about the new SEC rules for capital raisers for apartment syndicators. There's a lot of things a lot of discussions that have been happening around this, even prior to this new kind of proposal that the SEC has put out. There's a lot of discussions around that, and of course, now that the SEC has come out with this and given us a little more a rough guidelines and a proposal, it has created even more questions. So the purpose of today is not to be or replace your securities attorney. Absolutely, all the time, make sure you have a good, solid securities attorney to be able to help you navigate the waters when it comes to anything that has to do with the SEC. Our group has an SEC attorney, and I highly encourage you to do that as well. This webinar is purely for educational purposes. But we're going to dive into some of these questions that we have up here on the screen here about what are these new proposed rules? What's the breakdown between tier 1 and tier 2 raisers? What's the timeline for this? Why it's important for syndicators? And then what you should be doing right now to be able to help prepare for these types of changes. And so make sure that you pay attention to this. But before we get started, I wanted to tell you a little bit about myself. So I don't try to go into too much detail, but if you go to passiveinvesting.com, for those of you who are joining us live, I'll type it into the chat box for you. If you go to passiveinvesting.com, this is our private equity real estate website. We have on the page, you'll see this little link here that says Meet the Team. If you click on that, you will see that my name is right here, Dan Handford. I'm one of the 3 managing partners of the group passiveinvesting.com. And you can click on my name and find out more information about me. I do live here in Columbia, South Carolina with my wife and our 4 children. I have 3 girls and a boy. We actually just last week had our very first double-digit child. So our oldest turned 10 last week. So it's pretty exciting. I feel really old now that we have a 10-year-old living in the house, but we now have a 10-year-old, an 8-year-old, a 3-year-old, we have a 4-year-old, and then a 2-year-old that are in the house here. And we also have a standard dog poodle. So she's actually not down here right now with me because I'm actually broadcasting from my house today, but you might hear her barking if somebody rings the doorbell or something like that. So you can always go to our website, click on the properties and see some of the properties that we've closed and some additional knowledge information we put out there. We also have 2 current offerings that are available. So we actually just closed Braxton Cary Weston last week on Friday last week, which was actually our largest deal to date. It was a $57.6 million property, and we raised right around $21.5 million to be able to acquire that property. And we were able to close that on time within 60 days. So you can also go to our current offerings, click on this button here. This is our Riverside Flats at Aberfoyle Village. So if you're interested, this one is open for accredited investors only, and it is a 506c offering. So for those of you who are joining us live, I did type that in there for you to click on if you want to do that. It's a lot of information about this, some return metrics and things like that. And then you also have the ability at the bottom here to type in your name and information. If you are an accredited investor and you want to look at the details further, you can certainly do that, and we'll give you access to that offer memorandum on that property. We also have a short-term private lending fund, which is a 506c offering as well, open to accredited investors only. So you can find out more information about that. That one has a different structure than our typical multifamily offerings. It actually has a 6% preferred return, monthly compounding options that are available for it, and then you have a 90-day liquidity option. So if you want to find out more information about that, you can also go here and find out more information and do a little bit of a deep dive on that. So let's see. The last thing I wanted to mention is the MFIN Summit coming up in January. So you can go to mfinsummit.com and find out more information about this event. It's an online, all virtual event, and on January 21st, 22nd, and 23rd of just next year. So it's coming up very soon. And this is an event that we've been doing virtual since the very beginning. So it's not just because of COVID that we're doing virtual. We were the first ones to ever do the virtual events for multifamily events around the country. So this is our 5th time doing it. We do them once in January and once in June, and typically have right around about 700 to 800 people that come to that event every single January and June. So you can go there and find out more information and see the speaker lineup that we have coming up in January. And for those of you who are joining us live, I'll just type that back into the chat box there so you can join us there. So let's dive into this topic. So normally, as you guys probably have, any of you have followed me for some time, you know that I don't usually have a lot of notes prepared. I'm usually talking off of just from our already experience and try to have more of a discussion with you. And I want to have that discussion with you today. But one of the things I did is I went ahead and got some notes for myself, because there's a lot of new things that have been coming out about this new proposal that came out. It actually came out on October 7th, 2020. This is what is called a proposed rule by the SEC. And as a matter of fact, this was not an anonymous, not anonymous, unanimous. It was not a unanimous vote by the commissioners to actually allow this proposal to go forward. It was actually kind of torn. There was actually 3 votes for and 2 votes against it. And so there's still some questions as to whether or not this is actually going to go through or not, because what they do is they'll make this kind of a proposal, which this proposal allows for really kind of capital raisers, or what they call them as finders, to be able to allow them to be able to bring capital to a table to the table for an offering, and be able to get compensation based, be able to have compensation based or transaction based compensation, if you will, which normally is not allowed in these types of offerings and these types of transactions. Up until this point, they're making a proposal to allow us to potentially use this. And so what happens, just to give you an idea as far as the timeline a little bit, they usually allow for about 30 days of comments, or what I call it a comment period, after a proposal. And then of course they go back and they look at all those comments, and then they'll either do a couple of things. They'll either not do anything at all and nothing will happen with it, which could possibly happen. Or the second thing that could happen is they could come out with a new proposal and get more comments, which I would think that's probably more likely than not. And then the third thing that could happen is they take all these comments from the questions that they have put out there, because there was actually 45 questions that they put out there that they wanted some comments on from people. And they take all those and then they go back and they actually come up with an actual rule and have a ruling out there of what's actually going to happen. And so timeline wise, that's kind of what to expect as far as what could happen. How long it takes them to do that, I don't really have a good answer for you on that one. I've talked to a few people about that, and it could be a couple of months to a year to a year and a half. I mean, it just depends on how fast they're working. And obviously with COVID, a lot of things have been kind of being delayed. And then also with potential change of presidency, there's also the likelihood of some of this even changing even more. So a lot of that's kind of up in the air right now. But with this new proposal, they have 2 different tiers with it. They have a tier 1 and a tier 2 proposal that are what they call finders, is what the SEC calls them. A tier 1 finder is really just limited to you providing contact information of a potential investor, but you are not allowed to have any contact with that potential investor about the issuer, right? And the question is, when you're looking at these kind of rules, you have to ask yourself, well, who is the and Nick was asking me, are you sharing your screen? Yes, I'm sharing my screen, but I just have a discussion, Nick. So I don't have a PowerPoint presentation or anything like that set up. So the webinar registration screen is usually what I will stay on for right now. So going back to what I was saying is the tier 1 finders, they're limited to only providing contact information of a potential investor. And that tier 1 finder, though, may not have any contact with that potential investor about the issuer. Now, the question kind of comes in is about, well, what is the issuer? Who is the issuer? If I was going to put together a property or a deal, is the issuer passiveinvesting.com, or who is the issuer, right? And the issuer is really the entity that was created, because that is the issuer. The issuer is the entity that was created to be able to acquire that property, right? So you can't, as a tier 1 finder, go and, do some due diligence and vet a particular deal and then go find an investor and say, I vetted this deal. I've had contact with them about, about their process and their business plan. And I approve of it. I'm going to invest in it. Now you should as well, right? That would be you could not do that as a tier 1 finder. So there's definitely some limitations when it comes to that. So really kind of a tier one finder, when I look at it, I look at that and go, that's really more of an investor referral, right? If they just want to refer an investor over, then they could do that. Now, it's not that easy, because there's also some other, additional things that have to happen no matter whether you're a tier one finder or a tier two finder. There's some additional things that you have to do, especially the disclosures with that investor, which would have to be in place before any of this stuff could actually happen. The tier two finder, let's dive into that a little bit. You could actually solicit investors on behalf of the issuer. But one of the things you cannot do is you cannot do general solicitation. So even if it's a 506 Charlie, and the actual issuer is allowed to do general solicitation, you as the finder cannot do general solicitation, right? So there is a limitation there. You also, as a tier two finder, cannot provide advice to the valuation or advisability of the investment. So you can't tell them whether it is a good investment or a bad investment or anything like that. But there's a couple of things that you could do. So you're allowed to identify and screen and contact potential investors. You are able to distribute issuer offering materials to investors. You're able to discuss issuer information, including any offering materials, provided that the tier two finder does not provide advice, just like I said earlier, to the valuation or advisability of the investment. And you can also arrange and participate in meetings that are there on behalf of you and the issuer and the investor. Okay. So there's a couple of different, that's kind of the tier one and tier two. Now there's some conditions that both tier one and tier two have that you have to follow very closely in order to kind of, stay compliant, if you will. I'm not going to go over each one of these things. I'm just going to highlight some of them. If you want to find out more information, very detailed on this, you can actually pull up, you can also pull up on the SEC website, some of these proposals, but I'm gonna go through these things with you here really quickly. Gary is asking here, where do we find the recording? The recording will be sent out to anybody who registered for the webinar. So if you registered for it, it will be sent out to you and also posted on our YouTube channel in the archive for our webinars. So first off, like we said earlier, you're not allowed to participate in general solicitation. So what does that mean? That means typically a 506 Charlie issuer is able to pretty much advertise however they want to be able to promote investors to be able to invest with them. But in that 506 Charlie, they're only able to accept accredited investors, and they have to go through a verification process to verify by either a third party or looking at financial documents that they are an accredited investor. Okay. And then the next thing that both the tier one and tier have is they are only able to bring accredited investors to the table. So even if there's a 506 Bravo where you're able to bring in both accredited and non-accredited investors to the table as an issuer, you as a finder, whether you're tier one or tier two, cannot bring anybody unless they are an accredited investor. And with that same thing, you have to know that they're an accredited investor or have a reasonable belief that they are a potential accredited investor. That's kind of like the vague language that the SEC gives us when it comes to this proposal. And there might be some more additional, I'm sure there will be some additional clarifications as we move forward with this and the actual proposal is sent out. All right, so the other thing you have to do is, as a finder, you have to provide a services agreement, if you will, that is a written agreement that is on file between you and the potential investor. So you basically have to disclose at any given time what kind of compensation you're going to be getting for this referral or for this kind of finder, as a finder fee or compensation. So the kind of language is there's disclosure requirements that include providing appropriate disclosures of the tier two finders rule and compensation prior to or at the time of the solicitation. So before or at the time of that introduction to that issuer, there must be that file on that document on site that the investor knows that you as a finder are being compensated for that introduction. And then it has to be very clearly spelled out. And again, that's not an agreement that they're going to give you. The SEC is, and you got to reach out to your SEC attorney and make sure that they have a good proper written agreement out there for you as well. Now, there's a couple other exceptions or disqualifications for somebody being a finder, and there's two main ones that I found in my research. Is the finder cannot be associated with any type of broker dealer. So if you are associated with a broker dealer in any form or fashion, you would not be able to be a finder. Okay, you would have to work under that broker dealer and under the regular auspices of the broker dealer. Also, as a finder, you cannot be. You would be disqualified from becoming a finder and qualifying from these different rules if you had statutory disqualifications under certain rules that at the time that you were participating would disqualify you from being able to do that. And that's under section 3A39. I'm not going to get into all those things. Most of you, that's not going to be a big deal or apply to you at all. But again, you want to make sure that you do qualify and you're not statutorily disqualified. So a couple other things that you are as a finder cannot do, whether you are tier 1 or tier 2, is you are not allowed to be involved in the structuring of the transaction itself or even negotiating any of the terms of the offering itself. You also cannot handle any of the investor funds or the securities or being able to sign off to be able to bind an investor at all to the issuer, right? And then number 3, you cannot participate in the preparation of any of the sales materials or any of the sales offerings. And then you cannot perform any independent analysis of the sale yourself. And you cannot engage in any due diligence activities. Now, and again, this is my interpretation of this, but when it says not engage in any due diligence activities, prior to an offering, you could do due diligence, I would presume, on, say, passiveinvesting.com, right? And make sure that we're a legitimate group that you want to be able to recommend your investors to. But once there is an actual offering, that's the actual issuer of the offering. You can't go out and do new due diligence on that particular offering as well, right? And then make a recommendation to your investor as to whether or not that was a good investment or not, based on your due diligence of that particular offering. You cannot assist or provide financing for any of the purchases that have to do with the offering. And then you are not allowed to provide any advice to the valuation or financial availability or advisability of the investment as well. So going back to the beginning where I was talking about the timing on this, it's really kind of up in the air. There's not really any like concrete deadlines that they have or anything like that, but the commenting period has already expired, unless because of COVID they extended it, but I do not believe they have. So there's usually a 30-day commenting period that already ended on I think around those or last week sometime. It was issued out on October 7th, and they have 30 days to do it. It's October 7th, 2020. You have 30 days for commenting. And so that period has already been gone. But because there was not a unanimous vote of the commissioners, there's obviously going to be some extra scrutiny, I believe, in getting the final requirements down for this as well. So let me open this up for some questions. And I already know that I see a couple of these questions already coming in. So I will dive into some of these questions as they have been presented. So let's see here. Some of these are just comments. So let's see. This is just for the person who makes the referral, correct? I think that was a statement from earlier when I was talking about the tier 1 would be similar to a referral, but there would still have to be an agreement in place for that as well. So next question is, a tier 1/tier 2 raiser can only work with accredited investors. However, is there a minimum or maximum the investor can invest? No, there is no maximum that has been set for like a minimum or a maximum, but they do have to be accredited. So that is correct, Jerry. But there is no minimum or maximum that the investors can set. All right, says last week I raised $5 million for my offering in 2 days. We have accessed We have access of approximately 2 million in commits. We have excess of approximately 2 million in commits. I need more awesome deals to offer my investors. If you want to chat about partnering, here's my email. That's always a good problem to have. So I'll definitely reach out. Charles is asking, does being a part of the GP take you away from these qualifications? So it is my understanding that this is in addition to what the current rules are. So if you are part of the GP and you do certain responsibilities and you follow certain guidelines that are in place, then you don't necessarily have to follow these guidelines. These are, if you are not part of the GP and all you're doing is pretty much like basically acting like a broker dealer in some respects. It's not exactly, but so don't quote me wrong here, but you basically bringing equity to the table from your investors. They're going to pay you for that as a commission, if you will, for bringing that investor, but you don't necessarily have to have a part of the GP on there. Let's see. Is the finder responsible for certifying the accredited investor status? So no, they are not responsible, at least from the current proposal, they are not responsible for that. So you only have to have a reasonable expectation that they are an accredited investor. So obviously you'd want to have some proper documents in place, maybe a questionnaire, investor questionnaire, to make sure you had asked them or got their background and kind of see, they own a multi-million-dollar company. So they're likely, going to be an accredited investor. So there's definitely going to be some information about that. All right. So next question is, how is the proposal different from what exists today? Are there no limitations right now? So right now, you are not allowed to bring money to the table in exchange for a commission like that. So what this is actually doing right now, that you cannot have transaction-based compensation when you're in a 506B or C exemption from Regulation D and with the SEC guidelines. So the only way you can be compensated is that before you even go out with a project, you have to be on the GP of that property. You have to be an active role in it. So you can't just bring equity. There has to be additional things that you have to do, whether it be asset management duties or being a loan guarantor on the property or bringing some of the risk money. There's going to have to be something other than just bringing money to the table, if you will, and being compensated for that. And the compensation has to be set at the outset. It can't be set after you get into the deal. And what I mean by that is let's say you are going to bring $1 million and they're going to give you 3% of it, right? They can't change that and based on what you're going to be raising. So let's just say you said, hey, I want to join the GP. I have this skill that I can provide to you, and in exchange, I want to get part of the GP and a part of the acquisition fees, if you will. You're not allowed to be able to say, okay, well, however much you raise, we're going to give you X percentage equity and X percentage of commission off of that. And it changes based on the amount that you raise. That would be truly transaction-based compensation, which is a big no-no. So what this is doing is it's allowing us to be able to have a true kind of finder, if you will, where they're just bringing investors to you. That finder is not on the GP at all. So they're not associated with the issuer, other than the fact that they're bringing these investors to the table. And so now there's a lot more clarity with this, because there's been a lot of kind of unknowns about this stuff going on, and there's been some letters that have been sent out. Actually, lots of letters have been sent out to various syndicators around the country earlier this year that has caused a lot of kind of upset and angst around this particular topic. And I truly believe that this proposal for the exemption for finders was because of those letters that have been sent out. Now, this might have been in the works for many years, but it kind of, the impetus for really kind of pushing this through really early, right now, just last month, was because of that stuff that was happening earlier in this year. So we have another question here. When will we know the finalized details of the proposed change? We don't really know. So it could be, a month or two from now. It could be a year from now. Just depends on how fast the SEC wants to push this through and get some clarification. I personally believe that they do want to try to get this finalized and get this pushed out as fast as they can to get some additional clarification. So I wouldn't be surprised if maybe Q1 of next year we actually got either a final proposal or final ruling, if you will, that pretty much makes this legal. And then I wouldn't be surprised either if they in Q1, instead of having a final ruling if they had another proposal with some changes and open it up for more commenting, because a lot of times they can go through multiple rounds of commenting as well. If when will you if you're a finder who's not on the GP, if you're not accredited, would it allow you to be able to have your compensation put towards LP investment? If you're a finder who's not on the GP, if you're not accredited, would it allow you to be able to have your compensation put towards the LP investment? So I think to make that clean, what I would suggest, and again, I would definitely check with the attorney on this, but what I would suggest is if you're a finder who's obviously not on the GP, and again, none of these rules are finalized yet, so you can't follow these guidelines yet. So you have to wait until you have some finalized guidelines come out. So don't just go out tomorrow and start trying to become a finder, either tier 1 or tier 2. It's not ready yet. But when this does come out, if you are a finder and you're not on the GP and you're not accredited, as long as it's a 506 Bravo, because obviously a 506 Charlie, you do have to be accredited. If you're a 506 Bravo, I wouldn't see any problem with doing that. But to make it clean, I would go ahead and still get your compensation for your finder referral, if you will, or whatever the case may be there. And then you just turn around and invest with that as an LP in that investment. That's how I would do it to make sure it's clean. There's a paper trail that shows that as well. But there's actually, there's actually hasn't been any guidelines in here as to whether or not you are allowed or not allowed to be on the GP, or if your transaction-based compensation can be just, commission, like you get 3%, 4%, 5%, whatever it is for bringing up that equity, or if they're allowed to be able to give them a percentage of the GP based on the amount that they raise as well. So I think there's going to be some clarification that'll come out with that at the same time. Are other industries subject to these SEC regulations like oil and gas? So these guidelines for these finders is for any offering that would be under a 506, under a Regulation D, 506C or B or exemption. And I'm sure there's probably some other exemptions that are in some other industries that it would actually go for, but really this is not just for, like syndication and syndication space. It's for really, one of the main reasons why they're doing this as well is because a lot of small businesses use this as well to be able to raise equity for various things that they're trying to do in their businesses as well. Let's see here. Any limits on the amount of compensation? So far with the current proposal, there is no limits to the compensation. So that can be set however you choose. And last question I'll take for the day. Do not qualify for it, but if you want to find out more information about those additional guidelines, you can Google new accredited investor qualifications or whatever. But the main ones that most of your investors would qualify under is that to be an accredited investor, you have to have met one of two qualifications, or tests, if you will. So the first test is do they have at least $1 million of net worth that does not include their primary residence? So that's one way to become an accredited investor. The second way is by income. So there's net worth or income. Income is you have to have at least 200,000 of income if you are single, 300,000 if you are married for the last 2 years, and you have a reasonable expectation for it to continue in the current year. So that would also qualify you to become an accredited investor as well. And to become an accredited investor doesn't mean you have to pay a bunch of money or you have to take a test or do anything like that. You can either have these documents sent into a company. We use one called verifyinvestor.com. And for about, probably $75 or so, they will look at your financial documents that you submit to their secure portal. And within a matter of days, you can have an accredited investor verification document. I would not suggest doing that until you're ready to invest in something, because they are only good. Those verification letters are only good for 90 days. So after 90 days, you have to get another one. So the other way you can do it is you can have your CPA or your attorney review your documents for you, and then they can also sign off that you're an accredited investor. And then the third way to do it, which is what most syndicators don't do it this way, but you could do it this way, is you could have them submit all their financial documents to you as the issuer, and you verify that as well. But most people are going to choose to do it the third party verification, whether it's through their CPA or attorney, or they can go through that website, verifyinvestor.com. That's what it means to be an accredited investor. And I want to thank each one of you for being on here. Let me see if I actually have this next page ready to go, because I think we probably would. Let me refresh this screen here. Boom, here's next week. So for those of you who want to join us next week, we already have the next one ready here. It's going to be how to make the leap from single family to multifamily investing. So you can easily go to the link, which is, let me just resume my screen here. This is multifamilyinvestornation.com/MFIN webinar. So if you are interested in joining us for that next week, this is going to be Danny Randazzo is going to be joining you for that webinar next week. So he's going to be talking about how to make that leap from single family to multifamily. He's made that transition, and so he's going to jump on and spend some time with you and share his expertise and experience doing that and answer any questions that you have. So thank you so much for being on here, and don't forget to go to the mfinsummit.com and register for the event coming up in January 2020, and we'll see you back here next week.